The Ocean Shipping Reform Act, OSRA, was signed into law yesterday. Are you already breaking the law? A lot has happened this week in ocean shipping. Let's talk about it. Let's talk about what goes into effect right away and what's coming in the near term. I'll break it down. Hi, welcome to By Land and By Sea, an attorney breaking down the week in supply chain, presented by the Maritime Professor, me. I'm Lauren Beagen, the founder of the Maritime Professor and Squall Strategies, and I'm your favorite maritime attorney. Join me every week as we walk through both ocean transport and surface transport topics in the wild world of supply chain. As always, the guidance here is general and for educational purposes only. It should not be construed to be legal advice, and there is no attorney-client privilege created by this video. If you need an attorney, contact an attorney. So before we get into the discussion of the day, let's go through my top 3 stories of the week. So story number 1, OSRA 22. So this is the Senate version. It has passed and is signed into law. So the Ocean Shipping Reform Act, OSRA, has passed both the House and the Senate. We expected that to happen, and then it got signed very quickly. So remember, this is the Senate version. This version, the Senate version, was a little less restrictive than the House version. This version gave the FMC, the Federal Maritime Commission, a little more deference to determine unreasonableness standards and certain other standards that are now going to be kicked over into a rulemaking. You know, I still would have liked to have seen a little more time and deliberations for these changes to the Shipping Act, but overall, I think the final Senate version has some good improvements. I still remain the one major piece missing is giving the FMC the authority to deny alliances when they're filed. So we had talked about that a few weeks ago, maybe a month ago, about alliances and when they file their agreements with the FMC, that the FMC doesn't have the ability to just deny the agreement, deny the alliance. I also think that maybe there should have been a periodic renewal period for the alliances. That also didn't make it into OSRA 22. But maybe this is where the conversation starts. Not a terrible start. Earlier today I was on with the freight coach, Chris Jolly, and he asked me, what would you think? What do you think that this is an overall win? I'd say this is a 70% win. I think we're moving in the right direction. I think that there were still some things notably absent, but this was moving in the right direction. Something that only took a year to get to, where previously OSRA 98 took 8 years. I think we're okay. I think we're moving in the right direction. The president, like I said, signed this quickly. It was only 2 days later, which actually was yesterday at about 3:15 p.m. So get ready. The Supply Chain Port Infrastructure Roadshow is about to begin. I'm here for it. I've said this before, whenever the ocean shipping world is in the news, it's a good thing. I also think that as things make it into the news, so does bad information, misinformation. So it's on all of us to make sure that we're informed, that we understand it, that we're educating those around us and making sure that they understand it accurately and not just buzz lines and taglines. But the roadshow begins. There was a celebration that Speaker of the House held, Nancy Pelosi, when the bill finally had passed the two chambers, House and Senate. And then yesterday there was a lot of coverage of the president signing OSRA into law. So as background, just because we are going to be covering OSRA and Fact Finding 29 a little bit later, OSRA, this bill had been discussed informally in the Senate since the House bill, which was a little bit longer, a little bit introduced prior to the Senate bill, but it was formally actually introduced just February of this year, this Senate version. Like I said, the House version has been in effect since maybe the fall, maybe even beyond that. Like I said, we're about 1 year of deliberations and discussions on what now became OSRA 22. But this current version was just February of this year. I mean, that's 4.5 months ago? Not even very long. It was introduced by Senator Klobuchar of Minnesota and Senator John Thune of South Dakota. It was introduced in the U.S. Senate Committee on Commerce, Science, and Transportation, appropriately so, and then voted out of committee just a week later. Or voted out of committee March 22nd, and then a week later it actually passed the full Senate. So it moved pretty quickly. What happens now, you might ask? We're about to get into that. Is the president going to pop the ocean carriers in the nose with this bill? I mean, unlikely. We're going to talk about all of that in a minute. That was just story number one. So story number two, the ILWU, the International Longshore Warehouse Union, they're not likely to agree by July 1st for the Pacific Maritime Association. So this is last week we had an update provided from the ILWU and the PMA, the Pacific Maritime Association, labor negotiations. They came out and said not likely to agree by July 1st. Remember, this is the labor negotiations. The current negotiated agreement ends June 30th. So, I mean, what's that? 13 days from now. So they came out and said, look, we're not likely to agree by July 1st. However, one of the looming things that was hovering over a non-agreement or not being able to have an agreement as this continues forward was, are either side going to strike? Notably, is the labor going to strike? What came out in the joint press release was that no strikes were planned. So the joint press release just that came out last week recounted a meeting with the president, President Joe Biden, and the two parties, the International Longshore Warehouse Union and Pacific Maritime Association. They said, like I said, an agreement is not expected by the July 1st deadline. However, the joint release also mentioned that no strike was expected or planned. You know, I think anything can happen. I do appreciate that they're acknowledging that the industry had been a little concerned about a strike. But, you know, I mean, just because they said that it won't happen doesn't necessarily mean that things won't shift. But I do appreciate their commitment to not planning for a strike. You know, I don't know if anybody necessarily is, we're still 2 weeks out. So we talked about the whole labor negotiation and the history of the relationship between these two parties in one of my past By Land and By Sea shows. Look, it's not ideal. But not having a new agreement in place when the old agreement expires is kind of par for the course, as we discussed previously. You know, through the last few rounds of agreement negotiation, we didn't have an agreement on time. Actually, I think we'd be hard pressed to go back to when one was created before the current negotiated agreement ended. But look, the sky's not going to fall here. But here's the big question. How many more stressors and uncertainties can the already stretched supply chain take? I guess we're going to find out. We still have a few more stressors to go through here. I think labor was one of the big factors. I think COVID zero and what happens. Peak season's coming up, and then we start moving into, you know, I mean, we have, as part of all that, we have back to school. We have, nobody wants to be asking, is Santa going to come this year? And so I think a lot of shippers and beneficial cargo owners are maybe trying to take that cargo on earlier, but how do you put that into a warehouse that still is overloaded? You know, I think we're seeing that in some of the mainstream suppliers and shippers. It's going to be interesting for the next, oh gosh, I mean, at least 6 months at this point, until we get a little bit maybe closer to Christmas. I don't think we're going to have the sensationalism that we had last year. Maybe it'll still come into the conversation, but we'll see. So story number three. Look, this story is actually more of just a comment. I'm starting to take notice of some trends that are happening here. And this is maybe a word of caution. You know, be careful with some of the rhetoric of we have anti-big boats coming out. We have anti-ocean carriers coming out. Look, I mean, we need them. It is a service, but it's also a business. And so 90% of everything travels by ocean transit. And you know, if the ocean carriers were to say, well, America hates us and we have the money to reduce the service there, I mean, what if they do that? 90% of everything in the United States comes by ocean transit. And, you know, arguably you want to keep it a healthy two-way street. But on the other hand, you know, the rhetoric is just really mounting and it's really coming out hard against the ocean carriers. And some things are warranted and some things are very valid, but others aren't. And others is a little bit piling on. And I think that it's, you know, I think it's a little fanatical of a hypothetical of okay, maybe the ocean carriers are just going to say, nope, they don't like us anyways, we're out. Because I think that they need us as much as we need them. But let's be real, you know, yes, they've done some bad things, but the FMC is going and methodically tackling those. You know, the best thing that we can do as you know, interested parties in the ocean shipping world, by users of the ocean shipping world, the best thing we can do is stay involved with the FMC, stay engaged, keep watching what they're doing, keep filing complaints if you have bad acting that you see out there that's actually happened to you, or if you have tips that, you know, there is this bad acting going on and you suggest that the FMC should make an investigation. Last year, FMC Chairman Dan Maffei was I mean, more or less begging for complaints to be filed. He was saying, please let us know what you're seeing out there so we can act on it. They certainly have investigatory authority, but they also needed to know where to start, where to move. They've well started by now, but keep those complaints coming if they are valid and warranted. We don't want people just mulling in their in their, I don't know, frustrations. We want to make sure that those frustrations are being turned into action, because the longer that we mull in our frustrations, the more emotional, the more dramatized, the more heightened everything gets. And we have to keep it real here. We need to keep this on a reality-based assessment, because we're all in this together. We are all users of the ocean shipping world. Whether we like it or not, whether we're directly involved in it or not, we're all consumers. And unless you are completely off the grid, I'd argue, and maybe even then, because some of the tools that you're using, I don't know. I'm starting to see blanket statements about the evil empire of ocean carriers, calling them cartels when, our very own U.S. competition agencies responsible for monitoring and reviewing this stuff, the Federal Maritime Commission, the Federal Trade Commission, and Department of Justice, have actually said that there was vigorous competition. And maybe you disagree with that, but those are they have economists as part of their employees, and really nobody would rather find the bad acting, the non-competition, the monopolistic behavior than these agencies that have been really pushed and given the authority to go after this, but they're just not finding it, and they're looking at it in a neutral way. They are in the business of protecting the U.S. consumer, importer, and exporter. And if they're saying that there's actually vigorous competition, not mild competition, but vigorous competition, there is. We can disagree with it, but they're kind of approaching it from a neutral. My only point here being, let's tighten up our rhetoric. Let's stay honest about the complaints, because they are real and terrible, but let's not overbloat them. There are dangers with overstating and overbloating the industry pain points as well. Keep our complaints, keep these discussion points targeted, and then we can begin to address them. Look, I say this because, as we know, this week OSRA was passed, the Ocean Shipping Reform Act, and one of the president's main talking points was the ocean carriers increasing freight rates by 1,000% last week. That was his talking point last week. But the OSRA 22 bill actually does little to address this, and there may be a victory lap done here by many in the election cycle this fall. It's important for us to stay honest about our discussions. We're still cleaning it all up. There's some disconnects between the problems and the response, and OSRA begins the discussion, but it doesn't make it all the way there. Does OSRA completely solve the 1,000% rate hikes by the ocean carriers? No. Are we still going to see that as this shining beacon of the solution? I mean, probably. It's a complicated thing. Ocean shipping is a complicated thing. That's partly why I'm here. I want to make sure that we're presenting the facts, that we're getting both sides. I'm certainly not on the sides of the ocean carriers, but I'm also certainly not on the sides of all of the shippers either. I want to stay somewhere in the middle. I want to stay somewhere in the world of we're approaching all of this in a very matter-of-fact, educational way. And like I said, all that we do here on By Land and By Sea is for educational purposes only. I am an attorney. I do have clients, but for this purpose, these are educational purposes. And I think that it's important for us to have these conversations. So like I said, let's tighten up our rhetoric. Let's not pile on. Let's stay honest and really focused in what we're doing here, because we really want to make sure that we're effectively covering it and that we're not getting distracted. Well, with that said, let's get into the meat and potatoes of the day. So what's going on here? So OSRA 22, the Ocean Shipping Reform Act, was signed into law yesterday, June 16th, 2022. And there are some parts that are effective upon signing. There were also some initiatives that started the clock for must-be-done rulemakings. And like I said, this was all done on the heels of the Federal Maritime Commission's Fact Finding 29. We talked about that a couple weeks ago. That was Commissioner Dye's initiative that was then adopted by the full commission. There are 3 initiatives that have already been fast-tracked, including a new rule or including a new requirement or eventual requirement for terminals, ports, and ocean carriers. So what are some things that go into effect right away? Detention and demurrage invoices. This statute, this Ocean Shipping Reform Act, this modification of the Shipping Act, has some immediate effect on invoices and what's required to be included on invoices for detention and demurrage. Unreasonable refusal to deal, 30 days from yesterday. So 30 days from June 16th, so really mid-July, the FMC is required to start a rulemaking on unreasonable refusal to deal. The FMC is also required 45 days from yesterday, so 15 days later, so we're talking early August now, detention and demurrage prohibitive practices. So the FMC is already in the works of a rulemaking for detention and demurrage billing practices, but now this will be covering prohibited practices. This is going to be a little bit more content specific. And that's 45 days from yesterday. So that's early August. So now we have unreasonable refusal to deal in about a month, or it has to start within a month. We have detention and demurrage prohibited practices, 45 days. So we're talking early August. And then we also have unfair and unjust discriminatory methods, 60 days from yesterday. So early September, the FMC has to start a rulemaking on unfair and unjust discriminatory methods. This is a lot. This is a lot for the FMC to be basically assigned work. I think we're going to see at least a few of these start out as advanced notice of proposed rulemakings. So we've talked about kind of the different constructs that rulemakings can take. So we can do an advanced notice of proposed rulemaking is what the detention and demurrage billing practices rulemaking started out with. And essentially what they did, what all agencies do, but what the FMC did in this advanced stage is they put out some questions. They wanted to poll the industry to see what components the industry wants included. That would be my guess on how these go. They might have been doing some work already toward issuing a notice of proposed rulemaking. So a notice, so not advance notice, but a notice of proposed rulemaking would have a little bit more text to it, would have a little bit more, here's the direction that we plan to go. The advance notice is, here's the direction we think we might go, but we'd like some feedback. Are we on the right track? Are there different pieces that you would like us to relay into the final rule? Are there different areas that we're not considering? Are there other laws that we need to pair or partner up with this rulemaking? Really, I think the advanced notice of proposed rulemaking, these general blanket starting points, are probably the only way that the FMC is going to be able to keep up with these aggressive timelines. Look, it's not like the FMC doesn't have other stuff going on, right? They are the U.S. agency responsible for regulating all of the ocean carrier and all of the ocean shipping world. They have a lot going on. They already had their detention and demurrage invoice billing practices open. We just talked about that. That was the advanced notice of proposed rulemaking. And honestly, before all of this, I had expected that one, the notice of proposed rulemaking, the next stage of that rulemaking, to come in the next month or so. At this point, I don't know, maybe it's going to be hooked onto the detention and demurrage prohibitive practices that Senate delegated or directed the FMC. But even in talking about this right now, they're going to have to work on the confusion. So we have two detention and demurrage rulemakings running at the same time, or we will within the next 30 to 45 to 60 days. We have one for billing practices. That's the one that's already open. And then we have one for prohibited practices. It could get real confusing real quick, especially for the general public, especially while filing comments, and that's the whole point of these rulemakings is they go through this very laborious, like very kind of methodical. These are very prescriptive. These are very directed ways of making rules for U.S. government agencies. But they do that because they want to really ensure that the public gets an opportunity, if it's necessary, if it's a contentious thing, that the public gets an opportunity to weigh in. And so you also want to make sure that it's not too confusing to the general public and that the general public is able to file these comments. I'm going to stay on top of it. I'm going to stay trying to keep all of this clear for you. But there is a danger with the same topic with two simultaneous rulemakings. Like I said, we have the billing practices one, and then we have the prohibited practices one that will be coming. I don't know, D&D 1, D&D 2. We'll see. Maybe we're going to see them start to combine. Maybe we'll end up having a notice of proposed rulemaking or a reissuance of an advance notice proposed rulemaking that incorporates all of the things that had been kind of already fleshed out for the billing practices. And then we'll say, but also opening up for prohibited practices. And here's some questions. We'll see how they handle it. But what else are we looking at here? Like I said, we have OSRA, but we also had Fact Finding 29. And granted, these are recommendations. There were 12 recommendations that we covered a few weeks ago, but these are recommendations. But there's already some things that the FMC chairman has said are part of his list of things to do. One of such is the FMC's compliance officer required for ports, marine terminal operators, and ocean carriers. Look, ocean carriers probably already have some sort of an FMC compliance officer. Most large ports probably also have an expert on the related matters of FMC, and certainly MTOs, but maybe not all ports. And, we'll see what that looks like. I think that the FMC is probably going to move pretty quickly on that because they want somebody dedicated to FMC compliance. If you're regulated by the FMC, it behooves you to make sure that you know what those regulations are. And I think this is the one that's probably the most concrete, that now we're going to see a person at all of these different entities, so ports, marine terminal operators, and ocean carriers, that have a FMC compliance officer on staff. Maybe that's saying that the legal counsel is also the compliance officer. Maybe not. Maybe it's going to be somebody that's a little bit more technical. I think that this person is going to need to be able to interact with the FMC, respond to inquiries. It's supposed to kind of streamline it. I think that this is a good move. It's a little government in the hands, but I think that it makes a lot of sense to have a compliance officer at all of these entities, because it gets complicated. This is complicated stuff. And so whether they're hired on, who knows, maybe it's going to be an outside consultant also counts. Maybe it's going to be, it has to be somebody who's actually inside the agency or the authority. We'll see. The FMC is going to provide more information on that, but they keyed this, the FMC compliance officer recommendation from Fact Finding 29, as an important recommendation that they want to move quickly on. So what do we have? So like I said, in the immediate, we have detention and demurrage invoicing. So this is basically, again, this is general information. This is for educational purposes only. If you have specific questions about detention and demurrage invoicing, I recommend you contact an attorney and talk about your specific situation. But as a blanket statement, it looks to me that billing practices will be statutorily mandated with minimum information, and that was effective upon signing because it did look like there was nothing that said elsewise. And so what does that mean? So that means, as I interpret it, but like I said, educational purposes only, if there's a detention and demurrage invoice that doesn't have the following things contained on it, it might be a defunct invoice. It might be something that now the FMC is going to say that's illegal. That's contrary to the Shipping Act as directed by OSRA. And so what does that look like? And again, educational purposes only. But what was prescribed by Congress and the president as required, statutorily required now. So here's the different pieces that need to be on an invoice as of yesterday at about 3:15 p.m. The date that container is made available, the port of discharge, the container number or numbers, because like I said before, I said this many times, an invoice right now doesn't even have to have as before yesterday, an invoice didn't even have to have the container number that it was talking about on there. It just seems crazy. So now it does. The container number or numbers for the invoice. The exported shipments, if it's an exported shipment, the earliest return date, the allowed free time in days, the start date of free time, the end date of free time, the applicable detention or demurrage rule on which the daily rate is based. So that way you can actually look back, check where this rule came from, check where this amount came from, the applicable rate or rates of that applicable rule. And usually that's found in the tariff or the schedule. And so this is saying you have to connect it back to something. The total amount due, isn't that crazy that sometimes you might not even have the total amount due, or it might be a little bit confusing, maybe on purpose, maybe on not. So the total amount due in the invoice. This is interesting, and I like this. This is statutorily prescribed. This is what is currently required as of yesterday at 3:15, as I read it, because there's no guidance otherwise. The email, telephone number, or other appropriate contact information for questions or requests for mitigation of fees. So basically, if somebody has a question about that invoice, there better be an email, a telephone number, or some sort of contact information on there that's who they directly contact to ask questions about the invoice for detention and demurrage. Continuing on, a statement that the charges are consistent with any of Federal Maritime Commission rules with respect to detention and demurrage. This is interesting. It's basically saying, this is consistent with every FMC rule. And this, I'm not being shady here, is kind of how I read it. But a statement that these charges are consistent. Okay. We also have a statement that the common carrier's performance did not cause or contribute to the underlying invoice charges. Now, this is starting to kind of talk to, was there a change of schedule? Was there, was the common carrier's performance in any way part of the reason why the invoice is so high? This is interesting. The FMC has said, basically, if there is an unavailability of pickup, that you can't be charging detention or demurrage during those times, because it's impossible for the person to come correct the action. And these are supposed to be incentive-based. These are now statutorily required, all of these different items. This is very specific. I like to kind of say it's kind of a guardrail. What was provided here is a guardrail. And when I was talking to the freight coach earlier today, Chris Jolly, he said, it almost seems like this stuff didn't need to be said, or it's too bad that it needed to be said, because we're both a little bit along the lines of, maybe we'd rather have the government a little bit less in the weeds and kind of let the business take the direction. But, we can't, if an invoice goes out and says $3,000 and there's no information on anything that relates to that $3,000, and there's no who to call, there's no, any of that information, no container number. I mean, that's troublesome. You have to have some baseline what needs to be contained on a bill. So inaccurate invoicing, this also started yesterday. If the commission determines after an investigation in response to a charge complaint that an invoice was inaccurate or false, penalties or refunds could be applied or shall be applied. So this brings up something else that this new law, this OSRA 22, talks about, and that's charge complaints. So if there is a detention and demurrage charge that you disagree with, and I'm assuming that they're going to require some sort of attempt to resolve with the invoicer directly, attempts to resolve the charge complaint right off the bat. So if after that, the FMC is now going to be responsible for creating a charge complaint procedure. So some sort of procedure. So if you disagree with your invoice for detention and demurrage, if you disagree with your charges and you've tried to work it out, now you're going to have a direct area at the FMC that you can bring that complaint, and it'll be moved through in a quicker way. It's likely not to be a full adjudication. It's likely not to be cumbersome like a formal complaint. It's likely, I think the intent is really to be kind of quick hits with a quick hits turnaround. So what does this mean? So a person may submit to the FMC, and the commission shall accept information concerning complaints about charges assessed by a common carrier. The information submitted to the commission shall include the bill of lading numbers and invoices, and may include any other relevant information. So upon receipt of the submission with respect to a charge assessed by a common carrier, the commission shall promptly investigate the charge. So like I said, this is supposed to be a little bit quicker of a hit. This is supposed to be, okay, look, I got this invoice. They're not responding to me. I want to get this covered. I want to get this solved quickly, so we don't just have this invoice that, maybe there's going to be charges or late fees or whatever accumulating on it, but you disagree with what this invoice is even saying. This law now requires the FMC to create some sort of a procedure for this. And so they're also saying, upon receipt of the submission with respect to a charge by a common carrier, they need to promptly investigate. The ocean common carrier will also be provided an opportunity to submit additional information. Makes sense. If there's a complaint brought against the common carrier for their invoice bill, you would also like that ocean common carrier to say, well, hold on just a second. I have some things to say too, and that's part of what makes this all a fair process. However, the ocean common carrier will bear the burden of establishing reasonableness of any demurrage or detention charges. And so that's interesting. They need to prove that these were reasonable charges, not the other way around. They need to basically defend their charging of these detention and demurrage charges. We talked about this, or I introduced this, unreasonable refusal to deal. So 30 days from yesterday, June 16th. So like I said, mid-July, unreasonable refusal to deal. The rulemaking is required of the FMC. They were directed to work with the Coast Guard. And this is a nod kind of toward the export side of things. There were reports for a while that there were some vessels and carriers that were exclusively dropping imports because that's where they were making all their money, and just not taking exports. So they were bringing the imports because they were making money, and they were just turning around to go pick up more. This would help address that. Look, you can't unreasonably refuse to deal in the world of vessel space. This is obviously much larger than just the exports, but this is going to be something that's going to try to catch other bogus, unreasonable practices that may have arisen during this entire time. Continuing on, detention and demurrage prohibited practices. So 45 days from yesterday, so like I said, early August, this rule, detention and demurrage prohibited practices, shall seek only to further clarify reasonable rules and practices related to the assessment of D&D, detention and demurrage, to address the issues identified in the final rule published May 18th, 2020. We've talked about this before. So this was docket 1905. I suggest you go back and look at it. So it's an interpretive rule on detention and demurrage under the Shipping Act. So it's including a determination of which parties may be appropriately billed for any detention and demurrage or other similar per container charges. This last part is important, as I think the term detention and demurrage, even if it isn't called detention or demurrage, it will still be included. So per diem, daily rate, incentive for movement fee, container use fee. Look, these all quack like a duck. They're detention and demurrage. And the FMC, the law itself is starting to kind of nod toward that saying, or other similar per container charges. I think we're going to potentially see some creativity here, but I don't think that we're going to be able to get around the fact that these are all quacking like a duck. If they do, they're still going to fall under this. So the interpretive rule of detention and demurrage of May 2020 that's being referenced here, really kind of a few of the things that it covered. Dispute resolution policies, that's something that's going to keep coming up. So if you don't have dispute resolution policies, if you don't have a way for people to, dispute what the invoice that you're sending them, non-legal advice, but I think you should probably start working with either an attorney or figuring that out, because this is something that dispute resolution policies is going to be a big thing. The rule also states, the interpretive rule of May 2020, the rule also states that in assessing the reasonableness of demurrage practices and regulations, the Commission may consider whether and how regulated entities provide notice to cargo interests that cargo is available for retrieval. The rule also states, the interpretive rule also stated that absent extenuating circumstances, practices and regulations that provide for assessing detention when it does not serve its incentivization purpose, such as when an empty container cannot be returned, are likely to be found unreasonable. This was May 2020. Now we're seeing that in play. Now we're seeing the FMC saying, if there's an impossibility of incentivizing action, that's going to be an unreasonable charge. I mean, we had clues. May 2020 is when they first started saying this. So, nobody can really be surprised that now that's the movement. That's the way that they're moving. Also, another rulemaking, unfair and unjust discriminatory methods. We talked about this as being 60 days from yesterday. So this is the early September rulemaking. It must be started. So essentially, unfair, unjust discriminatory methods. What activities would be included in unfair or unjustly discriminatory methods? The FMC is going to have to start diving into this. This will certainly have industry input. This is going to be a beast of an issue to start wrangling. I mean, how do you define unfair, unjust? I think we probably have some low-hanging fruit here, but I also think, look, it's kind of like eating an elephant. And how do you eat an elephant? One bite at a time. We may not entirely solve it, but we can start, and we can start moving forward. And we can amend it as needed as we continue down the road, or as the FMC continues down the road. Fact Finding 29, the FMC compliance officer, I also think that that's going to be near term. We talked about that. I think that that's going to be an easy one for them to implement and say, we need an FMC compliance officer at an MTO, at a terminal, at a port, or at an ocean common carrier. I think that that's probably mostly something that all of these entities have, or some iteration of that. Now it's going to be a very dedicated thing. The law also says that within 60 days, a temporary emergency authority is given to the FMC to issue a request for information seeking public comment regarding a few different things. So one being whether congestion of the carriage of goods has created an emergency situation of a magnitude such that there exists a substantial adverse effect on the competitiveness and reliability of the international ocean transportation supply system. So whether the congestion has created an emergency situation, that's going to be part of the request for information. Whether an emergency order would alleviate this emergency situation, and whether the appropriate scope of such an emergency order. So it's basically going to be asking, what do you think we should be doing here? If this is an emergency, what do you think of the emergency? And how large do you think that this emergency order should be diving into the industry? Like I said, on the one hand, we want to make sure that the industry is still allowed, the business is still allowed to move forward in kind of a free market way. But on the other hand, you still need some guardrails. You still need to make sure that even though there might be, I think the FMC likes to maintain big losers and big winners, but we can't be just totally annihilating either side. And I think that's where the guardrails of the FMC, I think that's where we start to see that. So what's next? What's next after this immediate? We have a rulemaking on essentially marketplaces. So within 3 years, this is a new area. So essentially it's a shipping exchange marketplace. So no person may operate a shipping exchange involving ocean transportation in the foreign commerce of the United States unless the shipping exchange is registered as a national shipping exchange under the terms and conditions provided in this section and the regulations issued pursuant to this section. So what are they talking about here? I keep asking, what are they talking about here? It looks like this is in line with the work of NYSHEX. So what is NYSHEX? So that's the New York Shipping Exchange. So it's a digital platform that connects shippers with ocean carriers and provides contracts and contract reliability between the parties. So it's kind of like an open marketplace. So shippers are guaranteed that their cargo will be loaded and that the volumes committed for shipment will actually arrive. So shippers enter information about their shipments, and ocean carriers post specific offers that shippers can instantly accept. And shippers can then acquire guaranteed space on sailings that might take place pretty quickly, immediately, or maybe up to 6 months in advance. The key here is that NYSHEX doesn't actually mark up any of that transportation cost. So what's the problem? Why is this coming into play? I mean, why it makes sense that maybe it might be registered. There's some foreign entities that are also trying to get in on the game, and I think that the FMC is in the position of working on maintaining fair and efficient movement of goods for the benefit of the U.S. consumer, importer, and exporter. And when foreign entities start getting involved, the ability to monitor that is a little lost. And so this looks like it amounts to more of a registration than an actual meddling in the business or some sort of regulatory oversight more than just a registration. But having that nexus point to the business, I think is important. Should any of the practices of that business, of that marketplace or that, the shipping exchange go awry. And so it's starting to create a framework moment for the industry. There's 3 other rulemakings that are also prescribed. These are done in the Fact Finding 29. Talk about FMC is going to be busy, but so these were part of the 12 recommendations of Fact Finding 29. These were rulemaking on empty container returns, a rulemaking on earliest return dates, and a rulemaking to define merchant haulage and carrier haulage. I don't see these 3 as being hurried along, especially with the mandated rulemakings on the docket from the law itself. But arguably, these are some of the most important things to help alleviate congestion at the port, actually at the port. Remember, this was part of Fact Finding 29 and not part of the OSRA bill. And so as the FMC goes through and tries to determine where to start first, these weren't mandated by Congress. And so I think that that's where we're going to see, obviously, the congressionally mandated rulemakings first. But that doesn't mean that these have fallen off importance. I think that these are very important. So the commission also, on their Fact Finding 29, said that they would like to have a commission investigation into tariff surcharges and other charges. This was part of the 12 recommendations. This is critically important. This is going to go after all the bad activity that we've been feeling and that we've been seeing. And, just because you haven't been caught yet doesn't mean that you're getting off scot-free. The FMC is methodically and systematically going through the complaints. And this will give them even more oomph to review. These are investigations. This is the commission recommending investigations into tariff surcharges and other charges. So to really look at surcharges. So this is all for educational purposes. If you have direct questions, contact an attorney. But in general, if you have a surcharge, if you have a tariff surcharge or other charge, make sure that you can back it up. Make sure that you can identify why, maybe what that charge is for, if there's an operational component or whatever. But if you just say the Tuesday surcharge, you better have a reason why Tuesday required a surcharge. I'm just saying. Or at least that's what it looks like the FMC will be starting to look closer at. A National Seaport, Marine Terminal, and Ocean Carrier Advisory Committee. This is another Fact Finding 29 recommendation. I think that this is going to be in place probably by the fall would be my guess. It's going to be a little administratively difficult to set up, but I think that they already have advisory committees. And so the administrative side of it, of the pulling it all together, is probably going to be a little bit easier. So I think that they're going to be able to stand it up quickly, because what they do have is a National Shipper Advisory, which has importers and exporters on it. But notably absent was ports, MTOs, marine terminal operators, and ocean carriers. And so this is an important piece. Commissioner Dye has made sure to say that this was a piece that she wanted to see included in the conversation. I'm thrilled that this is going to be part of the conversation. So, I mean, that's all like in the next 6 months. That's what I see as happening even in the next 3 to 4 months. There's a lot that's going to be happening in the next 3 to 4 months. There's a lot that happens right off the bat. And look, even more, most of these have a must be completed within 1 year from the date of the signing of the law, which was yesterday. So it's a lot. I think the FMC can handle it. They've already constructively started. We've talked about this before. I think that they need some extra funding. This law talks about funding the FMC in a broader way. But I want to make sure that that's connected to some actual money, because just because a law goes through and says all this money, it needs to be tied to a funding source. And so it's not exactly clear to me if this is connected to a funding source just yet, or if this is just money that they'd like to send forward. I mean, the FMC is less than 120 people in the entire agency. They're going to need more. They're going to need more people. I think that we all need to enter into the next few months. I said this at the very beginning, with our eyes wide open. There's a lot that's going to be happening. We're going to be seeing trade in general even back out, whether it's because of this law or not. I think that some of the stressors that were previously there, certainly COVID and some of the COVID zero responses that were happening in Asia, I think those are going to start evening out maybe a little bit. But we've all been there. We've all been at an event where, you listen to the news afterwards and you're like, that's not exactly what it was. That's not exactly what happened. I'm going to stay here as a neutral perspective, or a provider of the information. We all need to keep an eye out. We all need to stay engaged. We all need to watch what's happening in the rhetoric and watch what's happening in reality. Staying engaged with the FMC. They've asked for the feedback, both through formal methods of comments filed, but also complaints, and also, tips, for lack of a better way of explaining it. They would like the public to stay engaged here, because they really want to get it right. That's it. That's it. That was a lot. I thought this was going to be a quick day. This was almost 45 minutes of discussion. As always, the guidance here is general for educational purposes. It should not be construed to be legal advice directly related to your matter. If you need an attorney, contact an attorney. But if you do have specific legal questions, feel free to reach out to me at my legal company, Squall Strategies. Otherwise, for the non-legal questions, the e-learning, the general industry information and insights by land and by sea is hosted by the Maritime Professor. If you like these videos, let me know. Comment, like, and share. If you missed any previous videos, these videos live on my YouTube page by Land and by Sea, presented by the Maritime Professor. And while you're at it, check out our website, themaritimeprofessor.com. We're still building out our e-learning content, but when it's ready, I'm going to let you know. It's coming together really great. I'm so excited about what's coming. So until next week, this is Lauren Beagen, the Maritime Professor, and you've just listened to By Land and by Sea. See you next time.